Hello, everyone. Welcome. My name is Paul Leong, and I'm here to welcome everyone because the SafeT Act will be affecting everyone. I'm a Naperville City Councilman. My name is Paul Leong, and Naperville is a great town. It is one of the best places to raise a family, great schools, great parks, great libraries, and one of the safest cities in this great United States. And I'm very proud of that. I am not a lawyer. I am not a judge. I am not a law enforcement official. And I don't play one on TV either. But there are people here who are. They work night and day to protect us and to keep us safe. So when I want to know about the SafeT Act, I want to hear from them. Because it's their job to interpret this law and to enforce it and to try to keep all of us safe. So thanks for coming out tonight. And I hope we all learned something. I'd like to introduce one of my fellow members of Naperville City Council, Patty Gustin.
Thank you, Paul. Thank you. We're going to get right into introductions. I'm so excited that we have individuals here who can speak to actually the substance of the law. First up, we are going to have John Curran, who is our Illinois State Senator. John Curran was sworn in to represent the 41st District in the Illinois Senate in July of 2017. Prior to the General Assembly, he served as Vice Chair of the DuPage County Board and was a board member from 2008 to 2017. Following 19 years working as an Assistant State's Attorney in Cook County State's Attorney's Office, Curran now works as an attorney at a private law firm in Oak Brook. He received his Juris Doctorate degree from Northern Illinois University College of Law and Bachelor's of Science degree from the University of Illinois at Urbana-Champaign. Curran and his wife, Sue, have 4 daughters and live in Downers Grove. He also has committee assignments with the state: Committee of the Whole, Appropriations, Education, Energy and Public Utilities, Transportation, Local Government, Subcommittee on Capital, Opioid Crisis Abatement Special Commission, and Public Safety Committee, and also Government Accountability, Ethics, and Pension, which is always a big one prior to this. So, Senator Curran, I'd like to have you come up and speak to the audience.
Good evening, everyone, and it's very nice to be here with you this evening. Before we get into the substance of really the Pretrial Fairness Act, which is a part of the SafeT Act, I wanted to just give you some background legislatively, where this came from, the genesis of it, and how we got here today before our experts. And we are so fortunate to have 2 of the best people in the entire state to talk about the Pretrial Fairness Act. So really, going back to 2020 and even 2019, before I didn't start on this committee, I took the spot of Senator Mike Conley on it. The Illinois Supreme Court had a commission that was studying bail and bail practices around the country to make recommendations to the state Supreme Court on changes to our bail process here in Illinois. Actually, Appellate Court Judge Leong Brennan was one of my fellow committee members on that commission. We were doing a very deep dive, talking to experts around the country on bail. Unfortunately, that process got short-circuited because the legislature didn't let the Supreme Court take the lead on it, and instead we started holding hearings in 2020 on bail and different aspects of criminal justice reform. Those hearings were largely, and I was also a member of that committee, those hearings were largely subject topics. There was no actual legislation, no verbiage for anyone to look over, nothing for experts to weigh in on, how something would be interpreted, how it would go into practice, but just general topics on criminal justice reform, where members of the General Assembly, Democrats or Republicans or advocates, thought maybe our system needed improvement or was failing the public or was failing particular individuals or groups. Ultimately, that process or that committee led to early January of 2021, and we had what we call a lame duck session. So the General Assembly is for a 2-year term. While I may get elected for a 4-year term as a state senator, because each representative only gets elected for 2-year terms, the General Assembly, you know, sunsets after 2 years, and you swear, and everyone is sworn in again, starting in January. So right up to when the General Assembly is going to end, and this year that's January 10th of 2023. They called the session, which was the lame duck session, and this is, you have members that are not coming back, their term's over, they may have lost their election or they didn't run again. This is basically the end of their term. And at that time, we had several items on, were placed on the agenda by the Senate President and the Speaker of the House. One of those was criminal justice reform, and that bill ultimately became the SafeT Act. There were a couple versions of it that were first filed. It was really about 8 or 9 different bills that were out there. There's some things in the SafeT Act, I will tell you, like that, you know, mental health assistance, mental health funding. There are some components on their own that were outstanding and would have had broad support. But rather running each item one by one, they did what they call an omnibus bill, and they put all together. So the parts that we thought were challenged and were going to cause problems, and the parts that were good. And this can be a common practice. You use the good to pass the controversial. So the night before the General Assembly was going to expire, or the day before, we were called. We still didn't have a final bill. We didn't have final language. We were just hearing rumors that this was coming. They had filed one version of it, and then they moved off that bill, and they would find another trailer bill. Ultimately, it was about 2 in the morning on the day that the General Assembly was going to expire in the Senate. When the bill was finally released, it was 800 pages, it was filed, and that was the SafeT Act. Unfortunately, we were given an hour to read it before it was going to be called for a vote. We do have a rule that something filed has to be, cannot be voted on for at least an hour. That needs to be expanded greatly. That is certainly not transparency. So at 2 in the morning, we were trying to make our way through 800 pages of a legislative proposal. It was called on the House or on the Senate floor about 3 in the morning. It was debated the best we could. However, everything was on the fly, and at 3 in the morning, it did pass the Senate with 1 vote to spare, so it got 31 votes in the Illinois Senate. Now, that was January of 2021. Some components of the bill went into effect right away. There was a component on electric home monitoring that would give individuals that are on electric home monitoring 2 days off of the bracelet out of 7. That went into effect right away, and that has since been being dealt with. The Pretrial Fairness Act, which was the largest portion of the SafeT Act, the effective date was put off for 2 years to January 1, 2023. They wanted to give the court system some time to work on it, work on the implementation. What we hoped would work on the obvious flaws and correct it. There have been 3 trailer bills to the SafeT Act since. None of those 3 trailer bills have touched the Pretrial Fairness Act. So instead of that part of the bill being worked on for 2 years, it was essentially set aside because the effective date, and they were dealing with more immediate concerns and issues that were arising from changes in use of force standards, policing, that had immediate or earlier effective dates that were problematic. And this was set off to the side. We are now approaching January 1 of 2023 when the Pretrial Fairness Act goes into effect. We have 1 legislative session between now and January 1 of 2023, and that is the fall veto session. And that is a 2-week session after the election. It's the week before Thanksgiving, it's the week after Thanksgiving. And if that bill, if that does not, something doesn't change on that, I think everything you're going to hear from the next two gentlemen, our state's attorney Bob Brennan and Appellate Court Judge Leong Brennan, they're going to lay out for you what the language going into effect, scheduled to go into effect January 1 of 2023 means, what its effect's going to be on the criminal justice system, the court system, and ultimately on public safety in our communities. So we're going to stick around, I know, to answer questions afterwards. I wanted to give you kind of a build-up as to how we got here, because I think, you know, I've heard from a lot of people, are they going to pass this bill? And you correct them, no, it already passed. You know, this passed 2 years ago. There was a lot of talk early on when it passed. You know, there was a lot of media coverage, but eventually the media moved on. And I think, you know, while the professionals in the court system and law enforcement didn't move on from the topic, you know, ultimately the public did. And now our attention is rightfully so back on this topic. So with that, I will bring Councilwoman Patty Gustin back up here to introduce our next speaker.
Thank you very much, Senator Curran. The next speaker we have is Bob Brennan, DuPage County State's Attorney. Bob has had a career as a prosecutor for over 35 years and counting. Bob Brennan was sworn in as DuPage County State's Attorney on December 14, 2010, after being appointed to complete the unexpired term of Joseph Burkett. In 2012 and 2016 and 2020, Bob was elected to full 4-year terms as DuPage County State's Attorney. He serves as the Chief Law Enforcement Officer for the second largest county in Illinois and leads an office of 87 Assistant State's Attorneys and 90 support staff and investigators. Bob?
Thank you, everybody. Thank you for coming out this evening. Let's see, here we go. So what I want to do in a relatively short amount of time is go through the actual law, show you aspects of the law, the actual language, and try and cut through the noise, okay? There is, unfortunately, a lot of misinformation out there, but I'm going to talk about the actual law and what it says, okay? So we're going to start out right now. We have cash bail. Defendants get charged, they appear in front of a judge hears facts about the case, about a person's background, here's mitigation, here's arguments from the state's attorney and a defense attorney or a public defender, and makes a decision on bail. And the law right now is that one of the factors a judge considers is that the defendant will not pose a danger to any person or the community. And that's something judges consider when they set bail. Starting January 1st, under the Pretrial Fairness Act, there is a presumption that all defendants will be entitled to release. There is no more cash bail, so judges have two options in most cases, and that is, actually, there's three options. They can release with conditions, or they can detain in certain cases. So there's a presumption of release. Now, after the Pretrial Fairness Act, the law says that the judge shall only impose detention when it's determined that the defendant poses a specific, real, and present threat to a person or has a high likelihood of willful flight. Notice one of the big changes in the new law, because it says real and present threat to a person. The community is taken out of the new law, the community standard. Or there's a high likelihood of willful flight, and I'm going to talk about what that means. This is the current law. This is what the law is right now, and you can see that in determining the amount of monetary bail or conditions of release, judges should consider the safety of any other person or the community. And that community is critical because that is where we get some of the significant bonds that we see in this county for violent crimes, for first-degree murder, for carjackings, for sexual assaults. When you hear about $500,000 bonds or $2 million bonds, it's most likely because someone is determined by the court to be a threat to the community. Okay, so this is the new law, starting January 1st. All persons charged with an offense are eligible for pretrial release before conviction, and pretrial release can only be denied when a person is charged with an offense listed in section 110-6.1 or when the defendant has a high likelihood of willful flight. And it's after the court has held a hearing under 110-6.1. The state has to file a petition and seek detention for eligible defendants, and then the court has a hearing. So these are the only two ways that a judge after January 1st can detain someone pretrial. And I'm going to go through 110-6.1 and what those crimes are that judges can hold people for. But first, let's talk about the definition of willful flight and what it means. And under the new law, what it means is that someone is planning or attempting to intentionally evade prosecution by concealing themselves. Not that they're a risk to miscourt, and the state has to prove by clear and convincing evidence. Planning or attempting to intentionally evade prosecution really means that they have a ticket to leave town, or they have told the police, if I get out on bail, I'm going to take off. The facts of the case do not help establish someone's intent to evade prosecution. So let's go through those crimes that are eligible for detention under 110-6.1. We start with subsection A1, and these are forcible felonies, but they are forcible felonies by which a sentence of imprisonment is required upon conviction. There are a number of forcible felonies where somebody can get probation, and those are not eligible for detention under this standard. Secondly, the prosecution has to show by clear and convincing evidence that the person's release poses a specific real and present threat to any person or the community. This is the only place where that community standard appears in the new law, under these forcible felonies for which you cannot receive probation. And these are the forcible felonies for which you cannot receive probation: murder, predatory criminal sexual assault, most of your criminal sexual assaults, residential burglary, aggravated arson, aggravated kidnapping, or any other felony which involves the use or threat of physical force or violence against any individual. That would include armed robberies, home invasions, aggravated vehicular hijacking, or carjacking. Those are forcible felonies that are detainable, where the judge makes a specific finding, again, that the person's release would pose a specific real and present threat to any person or the community. These felonies are forcible felonies, but they are subject to probation, so they do not fit under Section A1 and therefore are not subject to detention unless someone is a willful flight risk. Aggravated batteries, robberies, aggravated robberies, burglary, arson, kidnapping, threatening a public official, hate crimes, intimidation, second-degree murder, aggravated assault, and disorderly conduct threats against a school. The only way these defendants can be detained pretrial is if they are a willful flight risk, if they are planning or intentionally attempting to evade prosecution by concealing themselves. So again, for those probationable forcible felonies, a defendant's danger to the community or their risk to reoffend is irrelevant. They can only be detained under the willful flight risk standard. Now, these are the A2 cases. The A2 offenses are your stalking and aggravated stalking, and these are detainable. The state has to prove that the defendant's release poses a real and present threat to the physical safety of a victim of the alleged offense. So the victim of the stalking or the aggravated stalking. Moving on to your A3 offenses, these are many of your domestic violence cases, and the law is actually very strong in this regard in terms of domestic violence cases. So for here, it's again a real and present threat to the physical safety of any person or persons, and these would apply, these offenses are where the victim is a family member and there's an order of protection, or where the defendant has previously been convicted of a violation of order of protection, or the offender has a prior violent crime conviction against a family or household member. This section applies. Moving on to A4, again, these are domestic batteries and aggravated domestic batteries. Even misdemeanor domestic batteries can be detained if the offender is a real and present threat to the physical safety of any person or persons. So again, in terms of domestic violence, the new law is actually very strong. Moving on to A5, these are all of your sex offenses with the exception of the 3 listed on the bottom. Here, judges can detain defendants if their release would pose a real and present threat to the physical safety of any person or persons. Now, under A6, these are many of your gun crimes. Unlawful use of a weapon by a felon, which we have seen double in the past 2 years in DuPage County, and also aggravated discharge of a firearm, and human trafficking is listed in here as well. Here, however, the law requires the state to prove that the offender's release poses a real and present threat to the physical safety of any specifically identifiable person or persons. That is a different standard than in A1 through A5. Specifically identifiable person or persons means we have to name the person that they are a threat to. It is not a threat to the community. So your repeat gun offenders, unless we can prove that they're planning on attacking someone or hurting someone, this will not, a judge will not be able to hold them under this provision unless they're a willful flight risk. Moving on to A7, this is kind of your catch-all provision here. A person has a high likelihood of willful flight to avoid prosecution and is charged with any of those felonies in A1 through A5, or they're charged with a felony other than a Class 4 offense. So if you're a willful flight risk and you're charged with anything other than a Class 4, you can be detained. But remember that willful flight risk requires an intent or attempt to intentionally evade prosecution by concealing yourself. So your Class 4 offenses that are not detainable unless the defendant has a high risk of willful flight, these offenses include aggravated DUIs. All of your drug offenses can only be detained if someone is a high likelihood, a high risk of willful flight, because those offenses are not listed in A1 through A5. So all of your drug trafficking, your delivery of fentanyl, possession with intent to deliver fentanyl, drug-induced homicides can only be detained if someone is a willful flight risk. So, go back to the current bail law, because you see the phrase threat to physical safety of person or persons. This is the definition that is in the current bail statute. And what it says is a real and present threat to the physical safety of any person or persons includes a threat to the community. That's the current law. After January 1st, that same section is now blank because they have removed the definition of person or persons equals community, and they have removed that community standard, but for the one place that, where it appears for forcible felonies that are non-probationable. Now, these Class 4 felonies are truly non-detainable. Whether they're a flight risk or risk to the public or risk to a person, these offenses are simply not detainable under the new law, and that includes aggravated fleeing and eluding, which those numbers have gone up, I believe, sixfold right here in Naperville in the past year, according to Chief Jason Aries. Your disorderly conduct, threats against a school, not detainable, communicating with jurors and witnesses, concealing or aiding a fugitive, and obstructing justice, unless it's in furtherance of street gang activity. So, again, I mentioned earlier the state has to file a petition in order to have someone detained, and in the statute it states that in that petition the state needs to include the identity of the specific person or persons the state believes the defendant poses a danger to. Now that conflicts with other provisions in the law that talk about the physical safety, a threat to the physical safety of a person or persons, or for forcible felonies that are non-probationable, a threat to the community. Here it says we have to allege a specific person or persons that we believe the defendant poses a danger to. In this section of the statute, 110-6.1e, the law says that the state has to prove three things in order to detain someone. Number one, the proof is evident or the presumption great that the defendant has committed one of those offenses in A1 through A6, which I went through previously. Secondly, that the defendant poses a real and present threat to the safety of a specific identifiable person or persons. And third, that no condition or combination of conditions set forth in subsection B of 110-10 can mitigate the real and present threat to the safety of any person or persons, or the defendant's willful flight. So what you see here again is a conflict in the new law. Here it says real and present threat to the safety of a specific identifiable person or persons. So the person that commits, let's say, a carjacking, where he doesn't know the victim, just takes the victim's car, takes off, we have to show that that offender is a threat to a specific identifiable person by clear and convincing evidence. And it's going to be challenging to show that the defendant is a threat to that victim without some further threat of future harm. It's no longer good enough to show that the offender is a threat to the community because they may commit additional offenses while they're out. So even if, go back to that A1 standard, your non-probationable forcible felony, first-degree murder, okay, armed robbery, judge finds they're a threat to the community, in that instance they can be held. But at every court date thereafter, at each subsequent court appearance, in order to continue detention, judges must find that the continued detention or the current set of conditions imposed are necessary to avoid the specific real and present threat to any person or of willful flight from prosecution to continued detention of the defendant. Even if they were a threat to the community, at every subsequent court date, the only way to continue detention is for the judge to find that they are a specific real and present threat to any person. And again, that is not the community. So for violations of release, somebody's out on pretrial release, let's say they commit another crime. For Class B, these are for offenses, for felonies, for arrest other than a felony or Class A misdemeanor. If they fail to appear or they commit a Class B or C misdemeanor while they're on pretrial release, judges have to proceed under Section 110-3, and that means they have to issue a summons for the person to appear. They cannot issue a warrant. So the police have to go serve the person with a summons to appear, and then, if they appear in court, judges can impose sanctions for committing a new offense. And these are the sanctions that the law allows for: an admonishment, a fine, or imprisonment not to exceed 30 days, or they could modify the conditions of release. If they violate pretrial release by committing a felony or a Class A misdemeanor, then they can, in fact, be detained under the law. We will see more defendants released, and many of them will be released on some kind of a monitor, a home detention monitor. And the new law says that if someone cuts their monitor off or they're in violation, they cannot be charged with escape unless they are in violation for at least 48 hours. So they cut their bracelet off, they can't be charged unless they remain in violation for 48 hours. Under current law, as the law stands right now, a violation of bail bond. So somebody fails to show up in court, and I'm not talking about they fail to show up in court because they missed the bus or they're sick. I mean, they literally just ignore showing up in court and don't come in 30 days later. Judges issue a warrant. We then can go to the grand jury and we indict them for violation of bail bond. And the violation of bail bond is one class felony lower than what they're charged with. So let's say they're out on bond on a residential burglary, which is a Class 1 felony. The violation would be a Class 2 felony, one class lower. Under the Pretrial Fairness Act, a violation of bail bond, failed to show up in court, or any violation for that matter, is only a Class A misdemeanor. So you can be out on pretrial release for a sexual assault or a carjacking, residential burglary, whatever it is. You don't show up in court, that violation is only going to be a Class A misdemeanor. So what can be done about this? Myself and other states' attorneys have been urging, even before the Pretrial Fairness Act was enacted. 3 years ago, we sent a letter to the Pretrial Fairness Commission, which was created by the Illinois State Supreme Court, telling them that if they were going to get rid of cash bail, that they should use the New Jersey model. New Jersey eliminated cash bail in 2017. New Jersey's law differs significantly from the Pretrial Fairness Act in this way. New Jersey allows judges discretion in every criminal case to detain defendants if they're a threat to the community or a person, if they're a flight risk, if they're likely to intimidate witnesses or obstruct justice, or likely to intimidate jurors. New Jersey gives judges discretion. By all accounts, New Jersey's law has been a huge success. Judges, prosecutors, defense attorneys all say the same thing. There are actually fewer people detained in New Jersey. Their crime rate has not gone up, and they have over a 90% appearance rate in court. Illinois followed the New York model, and New York's model removes discretion from judges in many cases. The only way judges in New York can detain on a number of offenses is if the person is a willful flight risk. And that's the law that we have. And crime, the index crimes in New York over the past 2 years have gone up over 36%. There's a bill that was just filed a couple of weeks ago, Senate Bill 4228, which hopefully will be taken up in the veto session. This is a bill filed by Senator Scott Bennett, who's a former prosecutor out of Champaign County, and it follows the New Jersey model. The language is language that the state's attorneys were involved in drafting, and it allows judges discretion to detain defendants when they're a threat to the community, if they're likely to intimidate witnesses or obstruct justice. Okay, and we are hopeful. We are hopeful that there is going to be some movement, and that is going to be passed. Most of the state's attorneys in this state, including myself, in theory, do not have an objection to eliminating cash bail. But our position is, if you're going to eliminate cash bail, we need a strong preventive detention statute so that the right people are detained, the violent criminals. Everybody else has a right to get out. And the Illinois Supreme Court has said that people have a right to be released on bail, but that right has to be balanced against the public's right to be kept safe. And that's what we believe Senate Bill 4228 would do. Okay, one other thing I want to talk about, because there's been a lot of discussion about this. Many of you have probably heard about the police, their ability to arrest on Class B and C misdemeanors under the Pretrial Fairness Act. The law under the Pretrial Fairness Act says the police shall issue a citation in lieu of arrest for Class B and C misdemeanors unless the person is an obvious threat to the community or they have an obvious medical or mental health issue that pose a risk to their own safety. And I'm sure many of you have heard the examples the police have been using. If somebody's trespassing, which is a Class C misdemeanor, unless they're an obvious threat to the community, the police will not be able to physically arrest them and remove them. They can only issue a citation. In Senate Bill 4228, that language is fixed and does give the police the ability to make the arrest if they deem it's necessary. So in 2020, I'll finish with this. In the Chicago Tribune, there was an op-ed written by the former Attorney General of New Jersey, Chris Perino, and a former federal and state prosecutor in New Jersey, Ellie Honig. This is before the SafeT Act was passed, and they urged the Illinois General Assembly to follow their model. Our message to Governor Pritzker and the Illinois legislature is this: New Jersey reform works, and you should copy it, plain and simple. There's no need to reinvent the wheel. And they talked about how crime has gone down 29%. Incarceration went down 29%, but crime stayed the same in New Jersey. And they talked about New York's law and the two major flaws in New York's law, and that is that judges, the big one, judges cannot consider someone's danger to the community in many offenses. And unfortunately, as I said earlier, Illinois followed the New York law and not the New Jersey law. And this is what has caused all this uproar in the community before January 1st. So, again, there is still time to fix it. In the veto session before January 1st, we're hopeful that it happens. And again, I just want to make it clear that myself and many other prosecutors are not opposed to eliminating cash bail as long as we have a strong preventive detention statute. We have cases now where judges will set $3 million or $4 million bonds with the idea that someone will remain in custody because they're a danger, and they come up with the money and they get out. So with eliminating cash bail, we'll assure that those people stay in, but we put these cases in the hands of where they should be, which is judges. Judges are in the best position to make these decisions because they hear the facts, they hear the evidence, they hear the arguments, and they're the ones who have the experience to make these decisions. So I know I went through it very quickly, but hopefully it illustrated some of the issues with the law. But again, it is very fixable, and I'm certainly hoping that that occurs. Thank you.
Thank you, Bob. One quick question. You said that there were state's attorneys that put something together to support changes to this legislation in Springfield. How many state's attorneys do we have in this state, and how many actually were a part of that?
So there's 102 state's attorneys in the state, one for every county. We have a legislative committee made up of 15 of us, and we're the ones that had a role in the drafting. But periodically, we have Zoom calls where everyone is invited in the state. Some state's attorneys, I think over 50 now, have filed lawsuits challenging the constitutionality of the law. Myself and the Champaign County State's Attorney and the Kane County State's Attorney have a seat at the table with the legislative leaders who passed this law, and we are working on language which will hopefully fix the problems in the bill. And again, I'm hopeful that that will happen.
Thank you. Thank you. Thank you very much. Thank you. I do want to call Appellate Court Justice Leong Brennan here to the podium. Liam earned his Bachelor's of Art degree from the University of Notre Dame in 1989. Before attending law school, he worked at the Inter-American Foundation in Washington, D.C., and as a volunteer teacher at the Cardinal Spellman High School in the Bronx of New York. So you know about New York, huh? He then earned his Juris Doctorate from Loyola University, Chicago School of Law in 1993. Brennan's legal career started with 1 year as a civil practitioner, followed by 4 years clerking for the Illinois Supreme Court Justice James D. Heppel, and then 10 years as an assistant state's attorney for DuPage County, where he was promoted to supervisor of the Child Abuse Domestic Violence Unit. During this time, he tried over 60 jury trials and numerous bench trials to verdict. Judge Brennan was appointed as an associate judge for the 18th Judicial Circuit in 2008. In 2014, he was appointed and subsequently elected to the Circuit Court. As a trial judge for 11 years, Judge Brennan serves in various capacities, including as presiding judge of the Felony Division. Judge Brennan was appointed to the 2nd District Appellate Court in March 2020. Judge Brennan has served on a variety of Supreme Court committees, including Vice Chair of the Illinois Judicial College Committee on Probation Education, the Mission on Pre-Trial Practices, the Pattern Civil Jury Instructions Committee, the Pattern Criminal Jury Instructions Committee, and the Committee for Judicial Education. He also served as chair of the Illinois Judicial Bench Book on DUI traffic and as a faculty member for various judicial education classes. Judge Brennan and his wife have 3 children. Judge, come on up.
I did not write that. I also have a dog. State Attorney Berlin did an extraordinary job setting up the statute. I just want to talk a little bit about the impact this has had and will have on the judiciary. I just want to do a little before and after, though, before I get to that. Right now, in bond court, someone gets arrested in Naperville for a carjacking. And by the way, if a gun's not used or displayed, you can't detain on that kind of a carjacking. You can only detain under the new statute if a gun is displayed, but set that aside. So right now, they come into bond court, and the state's attorney, just to be clear, says, Judge, we have probable cause to believe that this person pushed Mrs. O'Leary down on the, when she was pumping gas, took her car. We caught him about 6 blocks away, and here he is. And we want, and the state will say, here's his background. He committed this offense twice in the last 6 years. He went to the penitentiary the last time that he committed this offense. And he also has been arrested multiple times prior to that, including as a juvenile. And we believe bond should be set at $500,000. We don't think he should be out. He's unsafe for the community. The public defender will then say, well, you know what? Mr. Jones has a full-time job. He supports 2 children. He's a hardworking guy. He's presumed innocent. Judge, he can post $300. Please set bond at $3,000, 10%, so he can get out and continue working, continue supporting his children. And he promises that he'll come to court. And then, the judge will pick a number typically. Let's say in this case, the judge picks $250,000, cuts it in half. And unless Mr. Jones can post $25,000, 10% of that, he's going to stay in jail until he either pleads or there's a trial and we have a disposition after a trial. That is what typically, that's what happens today. I'm leaving out a couple of steps, I apologize, but that's generally the gist of it. The idea of setting the bond from the judge's perspective is essentially public safety and or a concern for a specific victim if there's somebody that maybe this person's going to come after again. And public safety is kind of an amorphous concept, right? I mean, you look at their history, you look at their family, you look at their work history, what they're doing, their failures to appear in the past, and you just kind of make a decision. And it's not a perfect system. There's no such thing as a perfect system. But that's how it happens now. So after the George Floyd incident, I think that ramped up the interest in pretrial fairness and touching all kinds of parts of the criminal justice system to make it fairer, at least from the perspective of certain participants in the system. So that's where we're at today, and that's how we got to the Pretrial Fairness Act. And I have to say, reform is not a bad word. There's no such thing as a perfect system, and as Senator Curran pointed out, and as State's Attorney Berlin mentioned, I mean, no one's opposed to some of these reforms, but the devil is in the details. And the devil may be in some of these details. I do want to say something that's very important. As a judge, we are and the judiciary in general, we are going to apply this statute as best we can. That's our charge, right? We don't sit here and we have opinions, but we're going to follow this law. But this law is not so easy to follow as written, probably because it was passed really fast at 3 in the morning when Senator Curran was still up, but nobody else was. So we have had, since this passed, judges and other stakeholders working weekly and monthly to try to figure out what is this going to look like. So the bond court today, for example, in DuPage County, it has a morning and an afternoon bond court every day, and each of those takes less than an hour. It's expected when this goes into effect, if it goes into effect, that bond court could essentially, and we're planning on this, take the entire day or a big portion of the day every day, and that'll include on Saturday and Sunday. That's going to mean a difference in terms of how the judges staff bond court. It's going to mean a difference in how the state's attorneys and the public defender's offices staff bond court. And it's going to make a big difference in how our probation department, and that's an arm of the court, handles bond court. Because there's another concept here called the risk assessment. So there's an idea that, I talked about how kind of judges felt their way around setting an appropriate number. Well, there's another movement that's been going on nationally to create a risk assessment that's empirically based that would come up essentially with a number for the judge, 1 out of 10 or whatever the number is, 1 out of 4. There's a couple of different models that the judge will get the number, and the number will tell the judge or give the judge a guide whether this person is or is not a safety risk. And then that same pretrial probation group, they'll be responsible for tracking these people and monitoring them and giving them support if they're out in the community instead of back in jail like they would be today. This is predicting what's going to happen after the 1st. Here's the problem. We're very blessed in DuPage County, in Cook County. I don't know if they're blessed, but they have a lot of resources. Will County, I mean, we're resource rich up here. We have the ability to do some of the stuff I'm talking about. In large parts of the state, the court doesn't know what it's going to do. We're doing our best, but you're not going to be able to set this up. We've been trying, but there are circuits downstate where it's 7 or 8 counties is the circuit. The public defenders are part-time. There's no one to call to bring into bond court and do this, and it has to be done within 24 hours typically, or in certain circumstances, 48 hours. Who are we calling? Where's the probation people? Where's the computer systems and the models to come up with these risk assessments? So these are the types of things that the court has been working on to try to get ready for this. And I like what Bob said, that the state's attorneys are not inherently opposed to the elimination of cash bail. But I think he's exactly right that whether that's a good idea or not depends on what we call the detention basket. In other words, are you giving the judges the discretion to detain the right people under the right circumstances? And I won't editorialize, but you can decide for yourself whether you think the detention basket, who the judges can detain starting January 1st if it doesn't get amended, is the right basket. Some people think that the answer to that question is no. You know, I read these commercials and I look at them and I think about them, and I even think about what Governor Pritzker said about the reason we have the elimination of cash bail is so that, I think the example he gave a week or two ago is so that mothers who steal diapers don't have to sit in jail for months awaiting their case to be over. I think everyone in this room would probably agree that we don't want mothers who steal diapers sitting in jail for months waiting for their trial. But we don't throw the baby out with the bathwater, and that's potentially something that has happened. There are other concerns with the statute that are worth mentioning. One thing that hasn't been mentioned so far, except briefly, there are approximately 50 state's attorneys out of the 102 state's attorneys in the state who have filed lawsuits challenging the constitutionality of the act. I'm taking no position on that. That case could come before us. We're going to listen to the arguments, look at the law, the Constitution, and make a decision if that happens. But let me tell you what the argument, at least, is as it relates to that, so you know it. And basically, there are 3 aspects to it. One is, as we all remember from our civics, we have 3 branches of government. They're co-equal. They balance each other out. They cancel each other out sometimes, all for this magnificent country that we have, or state that we have. Well, the separation of powers, traditionally, a lot of these safety issues as it relates to the criminal justice system, setting bonds, monitoring people who are on pretrial services through the probation, which is the arm of the court, et cetera. These are traditionally have been judicial functions. So the question is, does the SafeT Act in some respects violate the separation of powers principle? That's one aspect of it. Another aspect of it is kind of in the weeds. No offense to Senator Curran, but the Illinois legislature continues to violate one aspect of the Illinois Constitution, which we call this the single subject rule. So, in Congress, they can pass a 10,000-page bill, and it can address 50 different issues, and they claim they read it. We don't know. But that's okay. The U.S. Constitution doesn't have any prohibition in that regard. The Illinois Constitution actually says every act can only deal with one subject. And this particular act, the argument is that it deals with a variety of subjects, and not just pretrial, but we didn't talk about it, but there's post-trial, post-conviction things, and that it deals with more than one subject. And the third contention in these lawsuits, 6 or 7 years ago, there was an amendment to the Illinois Constitution that was passed after a referendum that enshrined the Victim Bill of Rights. And the argument is that certain aspects of this statute violate the Victim Bill of Rights that's now in the Illinois Constitution. So I'm not expressing an opinion in any way on any of those issues, but that litigation has been consolidated in Kankakee County, I believe, and it will be interesting to see where that goes. So the courts are working diligently to try to anticipate issues and have answers. There are a number of unanswered questions that State's Attorney Berlin alluded to that are just going to have to be litigated. And it's unfortunate because perhaps had this been written differently and more stakeholders were involved, some of these things might have been anticipated. But we're doing our best as the judiciary, and we look forward to the possibility, I suppose, that the legislature, with the leadership of Senator Curran and State's Attorney Berlin, might make some amendments, but we'll see. Thank you very much.
Thank you very much, Judge Brennan. We are now going to the Q&A portion of the meeting, and we have a young gentleman here who has pen and paper. If anybody wants to write a question, please raise your hand. He'll come about. I do wonder if I can ask a question. I know I had spoken with a couple of my police officers. Naperville, just so you guys know, has a wonderful police department, if you didn't already know it, which I know you do. We actually put in our budget last year for body cameras, so all of our police now have body cameras. We also have, for years prior to the SafeT Act, had our police officers go through training for emotional, psychological intervention with individuals that may be in a difficult situation. So basically, you're not coming up to a car as an enforcer, you're coming up to a car as a community service person. And so it really has helped in the community because we do have quite a few people that have mental health issues or in a moment of time, they're dealing with something. So we really did want to give those tools to our police officers, and they have to go through the training, each and every one of them, so we're really blessed with that. So we have question. Okay. Instead of writing it down, why don't I just...
Thank you. First of all, I want to thank the presenters for their comments tonight. I heard State's Attorney Berlin speak last Thursday, and I kind of was vaguely aware of the issues, and it's got me kind of hyper-focused on them since I heard you speak, and I very much appreciated the slide presentation, which I would like to get from you if possible. Having said that, I think the question is, for people like me who are persuaded this is a huge mistake for this state to allow this statute go in effect as it is currently drafted, what should we be doing? I know what you're doing. I'm glad to hear there's legislation proposed. It seems like that, I've looked at the New Jersey model since last Thursday. That does seem to be a pretty good alternative. And so what should people like me, and I assume others in the audience, be doing?
Well, so, I mean, from my perspective in the legislature, and that's where, aside from the lawsuit that's been filed by state's attorneys that Judge Brennan spoke about, the ball's in our court to make changes. So it is really giving, amplifying your voice is what you can most effectively do. Contacting legislators, contacting the governor, expressing your concern, your disappointment, or encouraging thoughtful changes to this. Support, would be a great start. The reality is, and I'm going to editorialize for a minute, and these two are more in the professional nature. I represent a portion of Naperville in the General Assembly. Part of the reason this was, the implementation date was put to January 1, 2023, was getting past this election. Well, the reality is this election does somewhat become a referendum on this act. And that is also an opportunity to express your voice without telling you one way or the other. That is probably going to be your most amplified opportunity to express your voice. And that will give feedback in a very powerful way to the General Assembly prior to January 1st.
And to follow up with that, one of the audience question is there bipartisan support for Bill 4228?
Well, I mean, Bob, State's Attorney Berlin, and to our credit here in DuPage County, has been the main, or in the group of 3 state's attorneys working exhaustively on this issue to fix this and prod the process along. I can tell you, I am in the minority party in Springfield. The minority party has been frozen out from the get-go. We were frozen out back in 2020, late 2020 and 2021 on this, and we have been frozen out of the process with those 3 trailer bills that have passed, and that continues to perpetuate itself to this day, and that is an issue. I am very thankful at the state's attorney's work. I am hopeful if they get a good product put forward and we don't control what gets called, the majority party controls what bills get called, but I'm hopeful that their work is going to produce a proposal that actually gets put in committee and put up on the board ultimately for a vote that is a good product that is going to make us safer and fairer at the same time. Those 2 concepts are not mutually exclusive. We talked about that years ago when this process first came up, when this topic first came up. I had many discussions with State's Attorney Berlin, who's a tremendous resource for all legislators in the DuPage area, or really anywhere around the state. Fairness in the criminal justice system and the expectation of prioritizing public safety, the public's right to be safe in their community, are not mutually exclusive. So if we get there, I can't promise you, but I hope we'll see something that can be supported by both sides. But we're a long way from that right now. So,
let me just add one thing, and that is the law as currently drafted, the SafeT Act, is opposed by 100 of the 102 state's attorneys in the state. That includes both Republicans and Democrats. The lawsuit that's been filed by over 50 state's attorneys includes both Republicans and Democrats. And the 3 state's attorneys who are working with the General Assembly on the language right now also includes a bipartisan team. So from our perspective, in the State's Attorneys Association, it is bipartisan. It's just about public safety.
Thank you. A couple of these questions are redundant. I think we addressed them at the beginning of the presentation, but I'll read them, and if you can give a quick response. Will current detainees in county jail be released on January 1 based on the new law?
So that's an excellent question, and I can tell you what we're going to do in DuPage County, but there is a difference in opinion across the state. We, in meeting with our presiding judge and our chief judge, have determined that the law is going to be prospective only, meaning it will apply to all crimes committed beginning January 1st and thereafter. And the basis for that is a body of research, and Judge Brennan talked about the separation of powers. The defendants who are in jail right now have had bond hearings, and a judge set a bond. There's a court order, and the argument is that the General Assembly does not have the power to reverse an order that a judge has already set. We expect that there will be challenges to that. I know Kane County is also taking the position that it's prospective only, but my understanding is Winnebago County and Lake County are taking the position that it's retrospective. They're going to be doing detention hearings on individuals that the state's attorney believes can still be detained, and the others will be released. And Cook County still hasn't decided which way they're going to go. But the law is silent. That 764-page law is silent on whether it is prospective or retrospective.
Thank you. This is a different law, but can you comment on the recent proposed changes to charges for small amounts of drugs and fentanyl?
So the law you the bill, the legislative proposal you referenced did not pass both chambers. That passed the Illinois House on a very split roll call. I believe it was 61-47. It was never called in the Senate. So that bill, that proposal, specific bill, will expire January 11th at noon when the General Assembly expires. And the proponent of that bill will have to file again and start the process over again. So that is not law, but that is something that at least 61 members of the Illinois House thought was a good idea.
We're speaking of the fentanyl bill, or are you speaking of the small amounts of drug bill? They're both the same?
It's the same bill.
Same bill.
This was to, I'm sorry, what was it? House Bill 3447. And so that included up to 3 grams of fentanyl would be considered would be reclassified to a misdemeanor, an incredibly dangerous drug. I know, it is 1 gram of fentanyl is enough dosage to kill 500 people. This is an issue we debated in the Illinois Senate on a related bill. Senator Ellman had a bill in which she was seeking to give anyone in the vicinity, if they had something to do with the fentanyl usage of a person, someone that sold them the drugs, delivered the drugs, if there was cardiac arrest, cardiac issues after the ingestion of the drug and that individual was still present, they would be given immunity if they called the first responders. So that bill was debated, was never called, it was pulled from the record. There was no vote on that. There was great concern at that large quantity of fentanyl giving anyone immunity, even though we certainly want to encourage anyone, whether you're committing criminal conduct or not, to always act responsibly in a life-saving situation.
Thank you. The next question is, if the New Jersey model was so successful, why was the New York model decided upon?
So the genesis of the New York model is really it's a position paper and study by a policy group at the ACLU. So the ACLU, this is going back, I want to say 2010, 2012, and their goal was to bring down prison population in the neighborhood of 4% of individuals charged with a crime, I believe it was a felony, would only be detained. And currently around the U.S., that is a double-digit population. And I believe, and they were really the main proponents of this Bill, what was going on, even though, we were never at the table with them, but we know that they were one of the groups behind the legislators pushing this. They were also main proponents of New York, and they are critical of New Jersey because it has not brought down the pretrial detention population in New Jersey as dramatically as their organization hopes or as their policy position would call for. Quite frankly, I question, can you really, be concerned about community safety if you're looking to bring it down that low? So I know that's something, I've tried to figure out where this came from. And so ultimately, I think that was where the push to New York rather than New Jersey came from.
Is trespassing a non-arrest, non-detainable misdemeanor? If so, what can homeowners do to remove a trespasser?
So, under the Pretrial Fairness Act, the police shall issue a citation in lieu of arrest for a Class C misdemeanor, which trespassing is, unless the person is an obvious threat to the community, or they have some medical or mental health issue making them dangerous to themselves. There is no definition in the Pretrial Fairness Act of what obvious threat to the community means. And that's something that the police are going to have to determine. If they're an obvious threat to the community, the officer can make an arrest. But if they're not, they can only issue a citation, and obviously they will not be able to remove the person from that situation. And that is obviously the issue that many people have with that provision in the law. And the only advice, that I can give to homeowners is that, Sheriff Mendrick always talks about the continuum of force. There's a difference. If somebody walks into your house because it's 20 below zero and they just want to warm up, than someone who breaks in through the door at 3 in the morning intent on committing a crime in your home. There's a difference between the two, and there's obviously a difference in the type of force that a person can use to defend themselves or their family. And I can't get into specifics, factual scenarios, other than to say you should obviously pay attention to what the laws are in terms of self-defense. I would still rely on the police because almost all of the time, the police, especially the police here in Naperville in this county, will be able to resolve these situations, short of something violent. They are very professional and they're very well trained, and they know how to deal with these situations.
And to the issue of police, I know that there is conversation in the police department about imminent danger to them and when they can use their weapons. Can you explain a little bit about that discussion?
So this is part of the Pretrial SafeT Act that has already gone into effect, the officer's use of force. And there was a change to the definition when police officers can use deadly force. They have to consider the totality of the circumstances in a given situation. And in considering the totality of the circumstances, one of the factors is, can the person be arrested at a future date? Officers are called on to make split-second decisions, but if their life or the life of someone else is in imminent danger, police can still use deadly force in a given situation. Again, the language has changed, and how that language is going to be interpreted by the courts is something that will evolve over time.
And I only have 2 more. Because of multiple items on the bill, why bill did not go to general election for voters to get a chance to vote on? Good question.
Well, so what goes to voters for the general election or to vote on is proposed changes to the Constitution. It is also possible to put on the ballot a non-binding referendum to essentially take a poll from the voters. Neither path would have been immediate, and the proponents of this bill at the time were working diligently to seize upon, I think, the environment and the atmosphere that was out there, as Judge Brennan mentioned, in the wake of the George Floyd tragedy, and really the focus on the criminal justice system and policing and the fairness or lack of fairness in some aspects of it. And so to do that, they would have missed, this bill would not pass today. They would have missed their opportunity, to be very blunt. So that's why you didn't see a tact like that.
And the last question. Thank you for this informative session. You're welcome. What was the rationale for SafeT Act? Could you give more detail in addition to the need for pretrial fairness prompted by Floyd incident? Thank you. I kind of think you touched on that, but.
Yeah. So, I mean, again, the SafeT Act is a lot of different components, a lot of different individual bills. I can tell you one bill, there's a police licensing bill that requires the licensure of each police officer, like there are in other professions. That bill was heavily negotiated, that part, heavily negotiated. It was a standalone bill between the Attorney General, the chiefs of police. The language was gone over back and forth across the table exhaustively, and you know, whether you think that's a good policy or not, at the end of the day, there are no issues with the actual written language like there is with this. So, you know, this was really, it was just the opportunity, and the intent is to drive down detention, to empty jails, to try to drive that population down as far as possible. That's really the motive here. Whether this hit is going to hit the mark, is not, it's going to cause other issues. We know one effect of this bill is it is going to significantly drive detention, who's detained, or the numbers detained pre-trial down, because as was mentioned here, this bill really does tie the hands of the judiciary and takes decisions out of the judiciary, which is ultimately going to be problematic.
Thank you, gentlemen. I think the one takeaway on this is get yourself educated, which I think this has been a great forum to do that. Also, look up Bill 4228, right? Bill 4228, that would be helpful. You know, we have Republicans, we have Democrats, but really we have community, and we need to be talking to everybody, no matter what party you're with. Naperville is nonpartisan. We have to have these conversations. We may agree to disagree, but when they hear from the public, I hear from the public, Paul hears from, anyone hears from the public that's an elected official, we listen to what you have to say. And again, if you're an elected official and you're looking at, an 800-page document for an hour in the middle of the night, you know, the expectation of somebody getting all of that is really slim to none. And now we have an opportunity to fine-tune it, correct some areas of it, and have a better situation for the state of Illinois and for the city of Naperville. So wanted to thank everyone for being here this evening. NCTV, thank you for covering, and everyone have a wonderful evening.